The Supreme Court just dropped one of the most consequential emergency election rulings we have seen in decades, and it landed just last night. In a 6-3 decision, the highest court in the land has cleared the way for Alabama to use its 2023 congressional map going into the 2026 midterm elections. And here is what makes that so explosive. This is a map that a lower federal court had just ruled was intentionally and unconstitutionally discriminatory against black voters. The lower court looked the Supreme Court directly in the face, applied the new legal standard the high court had explicitly demanded just weeks earlier, and still said no. And the Supreme Court responded by completely overruling them, issuing a stinging written rebuke and restoring Alabama's map, all in a single emergency overnight order. That sequence of events alone is remarkable, but the full story is even bigger than that. If you think this is just an Alabama story, you are missing the entire picture. What you are watching right now is a coordinated, nationwide reshaping of congressional maps happening in real time, ahead of the 2026 midterms, driven by a Supreme Court majority that has fundamentally rewritten the rules of voting rights litigation in this country. This is about the future of the Voting Rights Act. This is about the future of the House of Representatives. And this is about how far federal courts are actually allowed to go when they believe a state is violating the Constitution. We are going to break every single piece of this down right now, from the beginning, so that you have the full context to understand what just happened and why it matters for every voter in this country. Before we go any further, if you find this kind of deep legal analysis valuable, please hit the subscribe button and leave a like on this video. It takes 1 second, it costs you nothing, and it makes a real difference in helping us reach people who need this information. Now let us get into this ruling, because there is a tremendous amount to unpack here, and the implications stretch far beyond one state's congressional map. To fully understand why what happened last night is so significant, you have to go back just a few weeks to what the Supreme Court did in a case called Louisiana versus Calley. Because without understanding that ruling first, the Alabama decision simply does not make complete sense. The two cases are directly connected, and the Alabama ruling cannot be read or understood in isolation from what Calley established. Think of Calley as the foundation, and last night's Alabama ruling as the Supreme Court enforcing that foundation against a lower court that refused to build on it. On April 29, 2026, the Supreme Court issued its 6-3 opinion in Louisiana versus Calley, a ruling that legal scholars have already described as a landmark decision that significantly undermines Section 2 of the Voting Rights Act. Section 2 is the provision of federal law that has historically served as the primary legal tool for challenging congressional maps, drawn in ways that diluted the voting power of minority communities. For decades, it has been the cornerstone of racial gerrymandering litigation in federal courts. Civil rights organizations have used it to force states to draw more representative districts. Federal courts have used it to strike down maps they found discriminatory. It has fundamentally shaped the congressional map of the United States for the better part of 4 decades, but here is where everything changed. The majority in Calais dramatically raised the legal bar that plaintiffs must clear to bring a successful Voting Rights Act challenge. Specifically, the decision now requires plaintiffs to prove intentional discrimination, which is an extraordinarily high legal standard to meet. Before Calais, challengers had a more accessible path to court. They could point to statistical disparities, demographic patterns, and the practical effects of a map on minority voting power and political representation. After Calais, they essentially have to prove that the state legislature sat down and deliberately, consciously, purposefully set out to harm minority voters. That is a fundamentally different and dramatically harder standard to satisfy, and it is already changing the landscape of redistricting litigation across the entire country. Justice Elena Kagan captured the gravity of this shift in her dissent, writing that the Voting Rights Act had brought the nation meaningfully closer to fulfilling its founding ideals of democracy and racial equality, and had been repeatedly and overwhelmingly reauthorized by Congress across administrations of both parties. Despite all of that history, despite decades of bipartisan congressional support for this landmark civil rights law, the current Supreme Court majority has now fundamentally reshaped what it actually protects in practice. That is not a minor doctrinal adjustment. That is a structural transformation in how one of America's most important civil rights laws operates. Now you might be asking, that is Louisiana, so what does it have to do with Alabama? Here's where things get extremely interesting. Pay very close attention, because this is where the real legal controversy begins and where the stakes become most clear. Alabama had carried a 6 Republican, 1 Democrat House delegation from 2011 all the way through 2025. The lone Democrat, Representative Terry Sewell, held a majority black district. That arrangement stood for over a decade without serious legal disruption. But after years of redistricting battles, the Alabama legislature drew a new map in 2023. A map that restructured the congressional districts in a way that concentrated black voters into a single district rather than spreading their political influence across two. That 2023 map was immediately challenged in federal court and has been at the center of a major legal battle ever since. Here is what makes this situation truly remarkable. The Supreme Court had already been involved in this specific Alabama litigation before last night. They had already sent the case back down to the lower court with explicit, direct instructions to reconsider Alabama's map using the new Calais framework. The message from the High Court was unmistakably clear. Go back, examine this map again, and apply the legal standard we just announced. There was no ambiguity in those instructions. But when the lower court did go back and reconsider the case, they once again ruled against the state of Alabama. Rather than align their analysis with the Calais framework, the district court entered yet another injunction blocking the 2023 map, concluding that it intentionally discriminated based on race in violation of the Constitution and that the Republican-controlled legislature had deliberately enacted a plan to dilute the voting power of black Alabamians. Let that sequence sink in fully. The Supreme Court issued a landmark ruling reshaping the legal standard for exactly this type of case. They sent the case back down with direct instructions, and the lower court applied the new standard and came back and said, still unconstitutional, still discriminatory, still blocked. That decision set off another emergency appeal immediately, because Alabama was genuinely out of time. The 2026 midterm elections are not a distant hypothetical. They are happening right now. Primaries are being scheduled. Candidate filings are underway. Voter registration deadlines are approaching. Election administrators needed to know which map they were actually working with. The clock had nearly run out. What you are about to understand is that this ruling did not happen in a vacuum. It came at the end of a legal chess match that has been playing out for years, and it happened precisely at the moment when the stakes were highest and the clock had nearly expired. That combination of timing and legal doctrine is what makes this decision so significant and so worth understanding in full. Alabama officials filed an emergency application asking the Supreme Court to block the lower court's injunction. State Attorney General Steve Marshall asked for a decision no later than June 1st, so the state could administer its elections in an organized and legally certain manner. That specific deadline tells you everything about how urgent and chaotic this situation had become for election administrators trying to figure out which map they were actually responsible for implementing. And then, just last night, the Supreme Court responded. They did not respond quietly with a brief unsigned order. They responded with a full, substantive written opinion that sent a very deliberate and very unmistakable message to every lower court judge in the country about what is expected of them. In a 6-3 decision, the conservative majority granted Alabama's emergency application, completely blocking the lower court's injunction and fully restoring the 2023 congressional map drawn by the state legislature. Alabama's elected legislature's map, not a map drawn by federal judges or hired outside experts, is now the map that will govern Alabama's 2026 congressional elections while the broader underlying litigation continues. But what matters most here is not just the outcome, it is what the Supreme Court said in their written opinion. They did not simply grant the requested relief and move on. They took deliberate time to directly, specifically, and pointedly criticize what the lower court had done, dismantling its reasoning piece by piece. The first major criticism was that the lower court failed to honor the presumption of legislative good faith. This is a foundational principle in American constitutional law. The presumption means that when a state legislature draws a congressional map, federal courts are required to start from the assumption that legislators acted lawfully, not from the assumption that they were engaged in a calculated scheme to harm minority voters. The Supreme Court said the lower court had this principle exactly backwards. Instead of requiring challengers to overcome the presumption of good faith with concrete evidence of discriminatory intent, the lower court treated Alabama's vigorous legal defense of its own map as itself constituting evidence of wrongdoing. The High Court said clearly and directly that this was legally wrong. The second devastating critique was that the lower court failed to properly apply the Calais framework when evaluating the challenger's proposed alternative map. Under the Calais standard, if you want to challenge a state's map under Section 2, the alternative you propose must perform just as well as the state's map when measured against every legitimate redistricting objective the state cares about. You cannot show up with a map that performs better on one dimension while ignoring every other criterion the state legitimately weighs. The Supreme Court pointed specifically to Alabama's interest in keeping Gulf Coast communities together and avoiding forcing sitting congressional incumbents to run against each other. The court concluded that the challenger's proposed map failed on these criteria and that the lower court should have recognized that failure and adjusted its analysis accordingly rather than substituting its own policy preferences for those of the elected legislature. The third major rebuke concerned the lower court's handling of racially polarized voting data. Courts use this analysis to examine whether voters of different racial groups tend to vote differently from one another in a given jurisdiction. The Calais decision made it clear that statistical differences in voting patterns between racial groups, standing alone, are not sufficient proof of illegal vote dilution. Courts must do the harder work of carefully separating race from partisan affiliation, because in an era of intense political polarization, voters often vote in blocs based on party identity, and those patterns cannot simply be attributed wholesale to racial identity without rigorous and careful analysis. The Supreme Court concluded that the lower court did not do this work, choosing instead to rely on analytical shortcuts that the High Court had already explicitly instructed lower courts to abandon. Beyond those three specific legal failures, there is another argument the Supreme Court embraced, and this one carries consequences that extend into every state facing redistricting litigation right now. The court stated that the district court had improperly inserted itself into Alabama's ongoing efforts to conduct its 2026 congressional elections under the map that its elected representatives had chosen. Critically, the Supreme Court rejected the lower court's defense that using the court-drawn map would be more convenient and less disruptive for election administration. The court's response was direct. It is not the appropriate role of a federal court to override a state legislature's lawfully enacted map simply because a judge believes a court-crafted alternative would be administratively simpler. This doctrine, sometimes called the Purcell Principle, has been a fixture of election law for years. But the way the Supreme Court applied it here sends a message that goes beyond the standard application. Courts that have second-guessed state legislatures on maps have historically justified last-minute interventions by pointing to the harm to voters from running under a discriminatory map. What the Supreme Court made clear last night is that the administrative disruption of changing a map at the last minute is itself a significant harm, one that courts cannot simply dismiss with assurances of administrative convenience. That is a meaningful and consequential shift in how the doctrine is being deployed. Now, to be entirely fair, this was a 6-3 ruling, and the dissent raised arguments that deserve serious consideration. In a blistering dissenting opinion, Justice Sonia Sotomayor, joined by Justices Elena Kagan and Ketanji Brown Jackson, argued that the majority was disregarding democratic values and the rule of law simultaneously. The three liberal justices did not simply disagree on procedural technicalities. They raised what they believe are fundamental concerns about the direction this Supreme Court is taking American democracy. Justice Sotomayor argued that Alabama had repeatedly resisted prior federal court orders and that the majority was now rewarding that very resistance. The dissent's core concern is structural. If states can simply defy lower court rulings, pass non-compliant maps, and then wait for the Supreme Court to bail them out on the emergency docket as election deadlines approach, it creates a profoundly perverse incentive. States can run out the clock on litigation, force the issue onto the emergency docket, and then claim that changing the map now would cause disruption, when that disruption was created by their own deliberate delay. The dissent also pointed to the concrete administrative reality on the ground, noting that mere hours remained before Alabama's voter registration records had to be finalized, and that restoring the legislature's map at that moment would require reassigning hundreds of thousands of voters to entirely new districts with essentially no notice. Justice Jackson, in separate writings in related redistricting cases, has raised the broader structural question of whether this court is genuinely applying neutral legal principles, or whether the pattern of outcomes is being driven by something other than neutral legal analysis. She has observed that the downstream beneficiary of most of these Supreme Court redistricting decisions has been the Republican Party. These are serious arguments. Thoughtful people can look at the same body of decisions and reach very different conclusions about what explains the pattern, but a dissent carries no force of law. When the dust settled last night, Alabama walked away with everything it had asked for. Now let us talk about what this ruling actually means for control of Congress. The court-ordered map the lower court tried to preserve had carved out 2 majority-black congressional districts out of Alabama's 7 total House seats. Given the state's deeply polarized voting patterns, a majority-black district functions in practice as a reliably Democratic seat. Under that arrangement, Alabama's delegation was set to be 5 Republicans and 2 Democrats. Alabama's 2023 map eliminates the second majority-minority district entirely, concentrating black voters into one district while diluting their percentage in surrounding areas. In raw political terms, that converts a reliably Democratic seat into a reliably Republican one. When control of the House comes down to a margin of 5 or fewer seats, as it currently does, that single-seat shift carries decisive structural weight. Think carefully about what that means at the national level. The House of Representatives is decided in individual congressional districts. Every district drawn is a political decision with downstream consequences for which party controls the chamber, which committee chairs are appointed, and which legislation passes or fails. Redistricting is not an abstract legal exercise. It is the machinery by which political power is allocated in a representative democracy. And right now, that machinery is being actively recalibrated in multiple states simultaneously, with the Supreme Court serving as the referee and, according to the dissenters, as an active participant tilting the playing field. The ripple effects travel far beyond Alabama. Since the Calais ruling in April, states including Louisiana, Florida, and Tennessee have actively redrawn or reinstated congressional maps designed to maximize Republican advantages, leaning directly into the Supreme Court's signal that state legislatures have broad discretion and are entitled to strong presumptions of good faith. With last night's ruling confirming the Supreme Court will aggressively step in whenever a lower court attempts to block those efforts. Legislatures in Georgia, South Carolina, and Mississippi are already positioning to redraw their own maps. We are potentially talking about 7 or more states where the balance of congressional representation is being actively renegotiated, all of it flowing from this chain of Supreme Court decisions. There is also the simple human dimension of what these decisions mean for voters who live inside these districts. When a map is redrawn, the person who represented you in Congress may no longer represent you. The issues that candidate campaigned on, the committees they serve on, the coalitions they belong to, all of that changes when a line on a map moves. For voters in majority-minority districts that are being reconfigured or eliminated entirely, that change is not abstract. It is the difference between having a representative who reflects their lived experiences and having one who does not. The Louisiana situation illustrates how far-reaching these disruptions have already become. Governor Jeff Landry declared an emergency and suspended the state's primary elections that had been scheduled for May 16th, citing the need for the legislature to completely redraw the congressional map in the wake of Calais. By the time the Supreme Court issued its decision in that case, more than 100,000 Louisiana voters had already cast early votes, and 42,000 voters had already submitted absentee ballots. Over 140,000 citizens voted in an election that was then suspended, and their votes rendered meaningless. That is not a procedural technicality. That is a fundamental disruption of the democratic process, and it flows directly from this chain of Supreme Court decisions. Alabama's Attorney General Steve Marshall praised the ruling as a major victory for Alabama and for the principle of self-governance. Whether you agree with that framing or not, it signals where this legal battle is heading nationally. He is not just celebrating one courtroom victory. He is making a broader argument about state sovereignty, the right of elected legislatures to draw their own maps without continuous federal court intervention. And that argument is now being validated by the highest court in the land. That validation will embolden Republican-controlled state legislatures across the country. The legal path to redrawing maps in a way that reduces majority-minority districts is significantly clearer than it was 12 months ago. This was an emergency stay ruling, meaning the Supreme Court acted on an expedited basis to pause the lower court's injunction while the full case continues toward a final decision. But the court also stated explicitly that Alabama is likely to succeed on the merits, and that language matters enormously when the Supreme Court says at this early stage that a party is likely to ultimately prevail. It is telegraphing how it views the full legal question. It is showing its hand. Alabama received essentially the strongest signal possible, short of a final ruling on the merits. The deeper questions this ruling forces into the open are the ones every citizen should be sitting with. If the Calais framework makes it this much harder to challenge racial gerrymandering under Section 2, what does that mean for minority voters who relied on Section 2 as their primary legal protection? What does it mean for representative democracy if the composition of Congress can be engineered through redistricting with far less legal accountability than before? What does it mean when over 140,000 citizens cast votes in an election that is then suspended and erased entirely? These are not abstract legal questions. They are questions about who gets represented in the halls of power and whose votes actually translate into political representation. They will be litigated, debated, and contested across this country for years to come. Here's what you need to take away from everything we have covered. The Supreme Court issued a 6-3 emergency ruling restoring Alabama's 2023 congressional map and blocking the lower court's injunction. The court explicitly stated Alabama is likely to succeed on the full merits, one of the strongest signals the court can send at this stage. The court directly and specifically criticized the lower court for failing to apply the Calais framework correctly, for inverting the presumption of legislative good faith, for improperly analyzing the challenger's alternative map, and for inserting itself into an active election without legal justification. This ruling is not isolated. It is part of a systematic nationwide reshaping of voting rights litigation happening right now across at least 7 states, directly ahead of the 2026 midterms, and the consequences for who controls the House of Representatives are potentially decisive. This story is nowhere near finished. More court battles are coming, more states will act. We will be right here breaking every development down for you as it unfolds. If you found this valuable, hit the like button, drop a comment with your thoughts, and subscribe if you have not already. Staying informed right now is not a luxury, it is essential.